Hi everyone and welcome to part 4 of this podcast series on business transfers. Today's session we deal with different nuances around employee transfer. One of the most critical aspects of slump sale deals is structuring transfer of employees from the seller to the acquirer. Considering that a lot of deals are structured around transfer of employees, that is, in acqui-hire transactions, the manner in which this employee transfer is structured is obviously of a key importance. So, Harshita, why don't you tell us what are the different modes in which employee transfer is structured?
Sure. Thank you, Khyati. There are two broad ways to transfer employees from one entity to another entity in India. Section 25 FF of the Industrial Disputes Act 1947 prescribes the option 1, which basically requires that where the ownership or management of an undertaking is transferred, whether by an agreement or by an operation of law, from one entity to another, then there are certain conditions to be fulfilled, to be fulfilled and complied with by the entity which takes over the employment of the employees. Condition 1, the service of the workmen should not be interrupted by the transfer. Condition 2, the terms and conditions of service as were applicable to the workmen after the transfer are not in any way less favorable to the workmen than those applicable to him or her immediately prior to the transfer. And third one being, the new employer under the terms of such transfer or otherwise should be liable to pay to the workmen in the event of retrenchment a compensation on the basis that his service has been continuous and has not been interrupted by the transfer. Now, very important to note here that Section 25 FF of the Industrial Dispute Act is applicable only to employees who fall within the category of workmen. For employees who are in the non-workmen category, there is no specific reference of employee transfer under the law, and hence the parties may consider a contractual transfer for such employees in compliance with the three conditions as indicated above, since that has been the market practice. Now, in view of certain case laws relating to Section 25 FF, we also recommend that employees' consent be obtained for transfer of employment, unless such consent has been previously obtained as part of the employment contract. The other mode of transfer of employees is resignation and rehire. As an alternative to the employee transfer route and with a view to provide flexibility to the buyer and also to ensure that the buyer is not taking on employment related obligations of the previous years of employment with the seller, the employees may voluntarily resign from their employment with the seller entity, or the seller may choose to terminate their employment. But what we've seen is that termination is rare, and it's usually the approach that is taken is that the employees will voluntarily resign while they accept new employment offers with the buyer entity. In such a case also, the three conditions that I specified when we were talking about Section 25 FF of the Industrial Dispute Act, they are not required to be complied with, since this is treated as a new employment relationship with the buyer. So broadly, when we are advising, these are the two options that we have seen parties adopt while they go for determining the best choice for the employees.
Understood, Harshita. Depending on which party you represent, is there a preferred route in terms of, out of the two options that you mentioned that you've seen in transactions?
Yes, so we do. So I think each of these transfer approaches, whether it is an automatic transfer under 25 FF for workmen and a transfer for the non-workmen, or if it is resignation rehire, they come with their set of advantages, disadvantages for each of the buyer and the seller. As an advantage, for example, when we are looking at transfer of employees, it's advantageous to the seller because they are not required to make any statutory payments that may be triggered upon a resignation or a termination of employment, including gratuity, severance, accrued but unused leaves. Whereas in case of a resignation rehire, the advantage could be that once the employees voluntarily resign, the seller may not be required to pay any statutory severance to those employees. The disadvantages in case of an employee transfer, is that for employees who are not transferred and they become redundant, the seller may be required to terminate their employment, which will have to be done in compliance with law. This could also lead to a litigation risk, and this mode has has witnessed extensive litigation in the Indian context, especially for industries where you see a trade union in operation. The disadvantage for a resignation rehire approach, is that the seller is required to make certain statutory payments at the time of resignation itself, which could be gratuity, which could be payment in lieu of the unused leaves. Then you have the severance payments and any other contractually agreed payments, because the service of the employee is ceasing, or is being terminated, or is the employee is resigning. There are a lot of these payments which will trigger and which the seller will have to bear at that time itself. And doing a resignation rehire for any and all category of employees, particularly workmen, has also seen and faced some challenges with the labor authorities.
Understood, Harshita. So apart from, the litigation risk that you highlighted, have you, as part of the commercial discussions and deals, seen typical issues when it comes to negotiating the clause around employee transfers?
Yeah, so I think one of the foremost issues that we've seen, being discussed heavily is, the pre-employment related liabilities. And the quantification of those liabilities. So whether, depending on the mode of transfer that is being adopted by the parties, the seller needs to quantify the accrued and unpaid liabilities towards its employees. For example, if it is gratuity, and let's say there are employees who have spent more than 5 years of service with the seller, and they're now being proposed to be moving to the buyer would want to know what is the gratuity amount, or what is their unpaid leave amount, unused leave amount that the seller has been accumulating or accruing in its books, which now, let's say they adopt the transfer approach, should technically be transferred to the buyer, or there should be a mechanism to adjust for that amount in the purchase price. So I think factoring in some of those liabilities, getting in actual valuation certificates for these liabilities or for these amounts that the seller had to maintain under law, or otherwise contractually, I think becomes a very critical point of discussion between the parties, and has seen a lot of, obviously, resistance from the sellers and the buyers alike, in terms of how they agree and how they negotiate to arrive at a common base for this.
Thank you, Harshita, for the legal as well as commercial insights. With this, we come to the end of part 4 of this series.